welcome to my channel. Today I'm going to talk about the most talked about Supreme Court decision about releasing one of the convict of Rajiv Gandhi murder case. She is Nalini Sriharan. So in this video you will be getting to know about what is the Indian legal system and why on what grounds that Nalini Sriharan got her release, and what are all the issues that happened, and what is the general chronology of events that has happened ever since the India's former Prime Minister Rajiv Gandhi was assassinated in his election campaign in 1991. So a brief history of what happened. India and Sri Lanka has always maintained historical relationships from time immemorial, and what happened here was after the British left both India and Sri Lanka, both the countries were fairly peaceful, but in Sri Lanka there has always been an ethnic conflict between the majority Sinhalese and the minority Tamils. Now, there was a secessionist movement from the Tamil-speaking people, and their cause was taken up by LTT, that is Liberation Tigers of Tamil Eelam, and they also had their sympathies in the state of Tamil Nadu. So, any political parties in Tamil Nadu had their sympathies with LTT. And what happened here was India, due to its geopolitical maneuvering and due to its foreign policy, had to support Sri Lanka. So hence it sent a peacekeeping force which enraged LTT and certain sections of the Tamil people. And it was believed that Rajiv Gandhi was completely responsible for this. And a lot of things has happened, a lot of water has gone down the bridge, and everything was going fine. And one fine morning during the election campaign in Tamil Nadu, Rajiv Gandhi was assassinated by a suicide attack. It was a very surprising thing because generally Tamil Nadu is a fairly safe, secured state when compared to its northern counterparts, and it was completely a mysterious thing. Why would someone do such a dastardly attack against India's Prime Minister in Tamil Nadu? And soon after the attack, and once things started falling in place, the natural suspicion fell towards LTT. And LTT initially had not accepted that they were responsible for it, but later it was felt that LTT was responsible, and a special court was set up, a special investigation team was set up, and the investigation team collected evidences, materials from various sources, and based on this evidence, a special court called TADA Court sentenced 25 people to death. Now this is unprecedented in Indian history, where 25 people have been given death penalty. Now these people appealed to Supreme Court, and Supreme Court found there were not enough evidence against 19 people and acquitted them, while 7 were convicted. And of the 7, 4 were confirmed death penalty and 3 were given imprisonment. And Nalini Sriharan was one of those who got the death penalty. Now at that point of time, it was a huge controversy because Nalini was pregnant, and we all know under international law or human rights law, it is against the spirit to hang a pregnant woman. So a lot of talk was happening, and the Congress Supremo, I would want you to remember that the former Indian Prime Minister Rajiv Gandhi belongs to a party called Congress, and after his death, his widow Sonia Gandhi took over as leader, and gave she she forgave Nalini and both the kids of Rajiv Gandhi. Now they are in active politics. Priyanka Gandhi and Rahul Gandhi. They also believe that they must be forgiven, and based on various sentiments and other issues, Nalini's death penalty was commuted to imprisonment. Now, so far, these were the legal issues. Later, politics started entering into the picture. DMK's Chief Minister Karunanidhi was a staunch supporter of the LTT movement, and he always sympathized with these people, and it was always believed that they did not had an active role to take part in the purported assassination of the former Prime Minister Rajiv Gandhi. Now later, another stalwart of the Tamil Nadu politics, J. Jayalalitha, she also started supporting these people and a release of these people. And at that point of time, the death penalty of three persons, Perialivalan and others, were kept pending. And in Indian legal system, in Indian legal system, once the Supreme Court has confirmed the death penalty, there is another option that a condemned prisoner can use, and that is the mercy petitions to president. And this mercy petitions, of course, India's president has to take this decision in consultation with the cabinet ministers. Now, I told you clearly during that point of time, both BJP and Congress were in power. Till 2004, it was the BJP-led NDA. Then, from 2004 to 2014, it was Manmohan Singh-led UPA, where Congress was the largest party. And despite Sonia Gandhi, Priyanka Gandhi believing in giving these people freedom, the party's stand was completely opposite. In fact, even after the current verdict, the party said that they are going to see if there is any way that they can go against appeal of this order of the Supreme Court. So despite this, ironically, their mercy petition was kept pending and no decision was taken on that. And this prompted Supreme Court to commute their death penalty to life imprisonment, because they believed that there must be some set time frame within which the decision on death penalties, the decision on mercy petition has to be taken. And keeping a prisoner indefinitely in death row without taking any decision on his or her mercy petition itself is a kind of torture, which is torture or violation of their fundamental rights or their human rights. And in Indian Constitution, as per Article 20, you cannot punish a person for a crime twice. The concept called double jeopardy. So, based on these concepts, the Supreme Court commuted the death penalty of the three remaining. Remember, I told you Nalini's death penalty was commuted way back in 2000. Now, in 2014, the remaining three persons, Santan, Perialivalan, Murugan, their death penalty was also commuted. So, after this, the question was whether they will be released. So, the death penalty was commuted to life imprisonment. But in India, usually life imprisonment runs to around 30 years. Although there is no set law on it, but that is the general convention. And after that, the question was whether these persons has to be released. And their conduct in the jail was exemplary. They studied and they got degrees, earned degrees. They were also involved in charity works, and they were very well mannered and well behaved. In addition to that, the general sentiment of Tamil Nadu public was in support of them. So there was a huge call for releasing these people, and there was also evidence that these people might have been innocent. They might not have been actively, or they might not have been aware of their accomplices who in fact carried out the attack was doing to kill an Indian Prime Minister. So they might not have been aware of that. And in 2014, the investigating officer admitted that he had tampered with the confession statement given by Perialivalan. He has tampered with the confession statement given by Perialivalan to give a more rosy picture to the court that Perialivalan was not just a passive accomplice but an active accomplice. Now, already the court have come down heavily on the government for not determining on their mercy petition. After this, there were elections, and AADMK Supremo J. Jayalalitha, she made a masterstroke. She called for the release of these prisoners. Now, under Indian laws, life imprisonment, anybody in life imprisonment can be released by the governments. The power is with both the state government and the central government. Now the question here was, since both the state government and central government has the power, what will happen if there is a conflict or if there is a divergence of views? Here the state government clearly wants the release of these people, but the central government was not towing that line. Now there was this became a constitutional question, because the state government said that we have every right to release these prisoners, but the central government said that because our central agencies were involved in investigating and prosecuting these people, the central government should have a say in this. There was some confusion of it. Then Supreme Court and other courts were discussing all this these years. And during this discussion, Supreme Court recently, 3 months back, gave a landmark judgment saying that once the state government has approved the release of a prisoner, then the governor has to abide by the decision of the state government's cabinet or the council of ministers. Unlike in USA, the governor or the president do not have an absolute veto here. The veto power of both the president and governor is qualified, that they can only delay a decision. They might ask for reconsiderations. Despite that, even if they ask for reconsideration, the state government is strong on their opinion or on their advice, then both the president and governor has to pass. Now clearly the state government has advised the governor to release these prisoners, but the governor has not taken a decision. And based on this, the Supreme Court released Perialivalan 3 months back, saying that once the cabinet of a state government has approved the release, then the governor has to take an action on it. And by not taking an action, just like by delaying the mercy petitions, there was also a violation of natural justice. And based on that, Supreme Court, under Article 142 of Indian Constitution, under Article 142 of Indian Constitution, the Supreme Court has extraordinary powers to undo any injustice done to any person. It can pass orders or judgments. So it passed orders or judgments for Perialivalan's release, and he was released And once that was done, it was just a matter of time before Nalini and others were released. The moment order of the Perialivalan came, Nalini approached the Honorable High Court of Madras, but unfortunately, the Madras High Court did not entertain the plea, saying that they do not have enough powers to entertain such plea. So later, these people approached the Supreme Court, and the Supreme Court has interpreted the Article 161, which talks about the relationship between the governor and the chief minister and his council of ministers, and they have told that once a decision has been taken by the state government, it is the responsibility of the governor to act on this decision as soon as possible, and by delaying that, the rights of these prisoners has been violated, their fundamental rights has been violated, and invoking its extraordinary powers under Article 142, the Supreme Court has passed this order. Now, my personal view is this is a fantastic judgment, because there are lots of uncertainties over their role in the crime, although there is no question that this is a crime that must be severely condemned in any civilized society. No political leader deserves assassination, whatsoever his ideas may be. So this is not something that we must accept as a part of civilized society. But here the question is different. Whether these people were actively part of the conspiracy is under doubt. And even if we consider that these people have committed those crimes, 30 years of imprisonment, and based on their conduct, good behavior, is sufficient for a criminal justice system to release these persons, because these people have reformed, and we are not living in 2000 years, we are not living in 2000 BC where retribution or vengeance will give results. Time and again, these kind of punishments have not brought any good to the society. So once these people are reformed, it is the law of the land, and it is their fundamental human rights to be released back into the society, to be integrated back into the society, and to do the good deeds. So in that regard, the Supreme Court has come out with a fantastic judgment. So in case you like this video, please like and comment on my video. I would welcome your comments. You can comment on it. What do you think of this decisions? And do consider subscribing to my channel. Thank you.